Hey everyone, and welcome. Today we're diving into something that's all around us, but most of us never see it. It's like an invisible force field that protects everything from your favorite song to the smartphone in your pocket. We're talking about intellectual property. It's the set of rules that turns a great idea into a real, valuable asset. So let's get right into it.
So let me start by asking you a question. What could possibly connect a #1 hit song, the phone you're probably holding right now, and the unique shape of a Coca-Cola bottle? I mean, on the surface, they seem completely unrelated, right? Well, maybe not. And there's the answer. The one thing they all have in common is that they are protected by intellectual property, or IP for short. Think of it like this. IP is the legal framework that protects creations of the mind. It basically gives you ownership over things you can't physically hold, your ideas, your brand, your unique way of doing something. Probably the best way to think about IP is to imagine it's a creator's toolbox. And just like in a real toolbox, you wouldn't use a hammer to tighten a screw. You've got different tools for different jobs. Each one has a very specific purpose for protecting a specific kind of creation. So for today, we're going to pull 3 of the most important tools out of that toolbox. First up, we've got copyright, which is all about your creative expressions. Then we'll look at patents for your groundbreaking inventions. And finally, we'll talk about trademarks, which protect your unique brand. All right, let's grab that first tool, copyright. This is going to be your best friend if you're a writer, a musician, a software developer, an artist, really anyone creating original works. But the #1 thing you have to remember about copyright is that it protects the expression of an idea, not the idea itself. And this, right here, is maybe the most crucial point to understand. Copyright doesn't protect a general idea. So it protects the specific lyrics you wrote for a love song, but it doesn't stop anyone else from writing their own song about love. It protects the exact words and sentences in a novel, but not the basic idea of a hero going on a quest. It's all about your unique execution. Now, here's what's so amazing for creators. Copyright protection is totally automatic. You don't have to register or fill out any forms. The second you write that sentence, record that song, or save that digital art file, boom, it's protected. And that protection lasts for a really long time, for your entire life, plus another 70 years after you're gone. Okay, tool #2. Let's talk about patents. If copyright is for expressions, patents are for inventions. This is the legal shield for something that's totally new, useful, and this is the tricky part, non-obvious. It can't just be a small improvement. It has to be a genuine inventive leap that an expert in the field wouldn't have just thought of. And this shows you exactly where that line is drawn. You could get a patent for a brand new specific machine that filters water in a novel way, but you can't patent the scientific fact that water can be filtered. See the difference? Patents are for the practical application of an idea, not for a law of nature or a mathematical formula. Now, this is a huge difference from copyright. Patents are absolutely not automatic. You have to apply for one, and you have to prove to a government patent office that your invention truly is new and inventive. If you get it, you're granted a 20-year monopoly. It's kind of a deal you make with society. You share your invention with the world, and in return, you get 2 decades to be the only one who can make, use, or sell it. All right, time for our third and final tool, the trademark. This one is different. It's not about what you created, but about your identity in the marketplace. A trademark is like a giant signpost that points to you and your products, telling customers, hey, this one's from us, and separating you from all your competitors. So a trademark can be a name, a logo, a specific color, even a sound, like the Intel chime. As you can see, Nike gets to protect its name and that famous swoosh logo, but it can't trademark the idea of selling sneakers. The whole point here is to avoid consumer confusion. It's about making sure when you buy a product, you know exactly who made it. And here's the really cool thing about trademarks. They can literally last forever. You do have to register your mark to get the strongest protection, but as long as you keep using it in business and you remember to renew it every 10 years, that brand identity can be yours, well, forever. So we've gone through the tools one by one, but the real magic is seeing how they often work together to protect a single product. And there's no better example than the smartphone that so many of us carry every day. It is a perfect showcase of how these different IP layers all stack on top of each other. Let's break it down. Okay, so first up, you've got the software code. All those lines of code that make up the operating system and the apps, that's considered a literary work. So it's protected by copyright, just like the words in a novel. Then you've got the actual technology.
Things like a special new chip that makes the phone faster, or a new way the screen scrolls, or some unique camera hardware. Those are all novel inventions, so they're protected by patents. And finally, what about that logo on the back of the phone and the name of the device itself? Well, that's the trademark. It's the brand. It tells you instantly who made that phone. So there you have it. One product protected by 3 different types of IP, all working at the same time. Now, it's great to have all these protections in your toolbox. But what happens when somebody ignores the rules and just takes your work? Well, that's called infringement. And this is where we look at what you can actually do about it. It's where the shields and force fields get put to the test. So what is infringement? At its heart, it's just the unauthorized use of somebody else's IP. It could be someone illegally sharing your movie, a company building a copy of your patented machine, or someone slapping a famous logo on a bunch of knockoff t-shirts. It's all infringement. And if your rights are infringed, the law gives you some pretty powerful tools to fight back. First, a court can issue an injunction, which is a fancy word for an order that says, stop, now. Second, you can get damages, which is money to pay you back for what you lost. Or you could go for an account of profits, which forces the infringer to give you every cent they made from your work. And finally, the court can even order a delivery up, making them hand over all the copied items so they can be destroyed. Now, I know it's easy to hear words like patent and infringement and think this is all just a game for giant corporations with teams of lawyers. But that could not be further from the truth. This whole toolbox we've been talking about, it's for everyone. Whether you're a musician uploading your first song, an entrepreneur designing a logo for your new business, or an inventor tinkering away in your garage, understanding these rights is what gives you power. It's what lets you own your work, control it, and hopefully benefit from your creativity. It is your right as a creator. So as we wrap this up, I want to leave you with one final question to think about. Look at your own work, the projects you're passionate about. What are the valuable ideas and creations you're putting out into the world? And now that you know a little bit more about the tools in your toolbox, what are you going to protect?